What up, YouTube? It's your boy Sim the Goat 5, man. Back with a new one, you know what I'm saying? We got a good one for you today, man. P. Diddy is in court, finna be in court in about a few minutes, you know what I'm saying? So we finna get on into that. It's live coverage of his hearing today, and we're gonna see what's going on with that, man. If you hadn't already smashed that like button, man, subscribe to the channel, you know what I'm saying? Do all that. Tune in. Let's go. Make sure you get in the comments, man, and hit that like button. Share the live. Smash that like button, man. Everybody smash that like button. Live coverage.
Hey there, everybody, I'm Jesse Weber, and welcome to Law and Crime's special live coverage of Sean Diddy Combs. Big day today. So Judge Arun Subramanian, who is the judge overseeing the Sean Combs criminal case, has scheduled a last-minute evidentiary hearing. And this is important because this concerns whether or not the government deliberately breached the attorney-client privilege. This is a live shot outside of that courthouse. Law and Crime's very own Elizabeth Milner will be inside that courtroom coming back out to us to explain what has been going on. I'll get into it in a second, but I have to explain what the basis of this is. Now, in the filing, Sean Combs' defense team, or in the filing that they submitted with the court, Sean Combs' defense team has cited, quote, outrageous government conduct after 19 pages of materials were seized from Sean Combs' jail cell and allegedly were given to the United States Attorney's Office. These materials that were obtained during a jail sweep include Combs' quote, privileged notes to his lawyers concerning defense witnesses and strategies. Combs' attorneys described this sweep as a targeted seizure, that this is a due process violation. They have called for the state to, I should say the federal government, to answer a series of questions that are listed in this filing. So first they want to know who authorized the search of Mr. Combs' sleeping area, personal effects, and paperwork. 2, who determined what paperwork to take. 3rd, who decided to give this paperwork to the United States Attorney's Office. 4, who decided to give this paperwork to trial prosecutors. 5th, who made the decision to not tell Mr. Combs' counsel that the U.S. Attorney was in possession of his notes, including possibly privileged materials. And 6, exactly what material was taken. Now, the government has fired back against this. They believe that this evidentiary hearing is unnecessary, that this sweep wasn't targeted. And one of the things that they have highlighted in their most recent filing is about photographs that were taken of Sean Combs' notebook and his address book that were found in his cell. They write, the photographs and what is depicted in them are not privileged. The defendant doesn't argue, nor could he, that the notes in the photographs were prepared for the purpose of obtaining legal advice. Contrary to defense counsel's mischaracterization, the photographs do not reflect notes to lawyers concerning defense witnesses and defense strategies. Rather, the photographs depict the defendant's wide-ranging notes to himself, including notes related to the defendant's business interests, his release of music, and family matters, among other things. Under the law, these sorts of notes are not protected by the work product doctrine. And to be clear, according to the prosecutors, no physical materials were actually seized from Sean Combs, but rather there were just photos that were taken, and as an abundance of caution, they were redacted. These photos were redacted, and then they were provided to the case team for review. So obviously, you're seeing two different sides of the coin here. And ahead of this hearing, Mark Agnifilo, who is Sean Combs' lawyer, one of his lawyers, requested that Sean Combs actually be unshackled today, and for all future hearings, Judge Subramanian actually granted that. Now, reminder, we're not going to see it. There are no cameras that are allowed in this federal courthouse, unfortunately. But, as I mentioned, we have our very own Elizabeth Milner, who will be in that courtroom. She's going to come out later, report to us about her observations from what happened inside. We're also going to be providing live updates of what is happening inside that courtroom. And so as we do that, we're also going to be taking your questions. So if you have questions about the case, if you have questions about the hearings, make sure to submit them on our YouTube page. Want to get started right now. I'm not doing this alone. I want to bring on two special guests. I'm joined by criminal defense attorney Mauricio Padilla and also criminal defense attorney Safa Robinson-Frere. Great to have you both here. Mauricio, I'll start with you. What do you make of Sean Combs' request here? Or let me put this way. Sean Combs not only requests for a hearing, but the accusations they made against the government.
Well, I mean, I'm glad that he requested a hearing. I've never seen ever this type of, investigation where they're going in and taking pictures of legal pads. I'm not surprised that they're doing it, but in my experience, I've never seen it done. I don't know exactly what the pictures were of, but the fact that it went through a filter team, that they never reached out to, the criminal defense attorneys, it really raises an eyebrow regarding the government's actions and how they're really treating this case. I mean, Diddy must know that they are looking at every single thing. They are listening to every single phone call that he's making. I heard that he's making three-way calls, that he's breaking the rules. But when it comes to Diddy, he can't stop because he won't stop because he can't stop. So I'm not surprised.
Damn.
I'm not.
I knew you were planning.
I had to do it.
You're probably figuring out a way to use that all for this whole show, and you're like, you know what? I'm not going to save it for a half hour, and I'm going to save it for my first answer. So just to provide a little bit more perspective on this, if you've been following us here on Law and Crime, you've been following us on Sidebar, you know that the feds actually raided the Metropolitan Detention Center where Sean Combs is currently housed. They were it was a pre-planned sweep. They were looking for contraband, and what the prosecutor said is during the course of this sweep, they looked into Sean Combs' jail cell. And there was an investigator that was part of the Bureau of Prisons that was looking into things. And they write, in the prosecutors write in their filing, on the defendant's bunk, investigator 1 found the following items: manila folder marked legal, a notebook labeled, and that's actually redacted, an address book, personal effects, and talking about not that they just took out materials and looked at everything, but took photos of it, sent it to a filter team. Filter team sent it to the prosecutors. That's my understanding. Safa, I'll give you an opportunity to respond to what you think of the defense's argument and the prosecution's response. But I guess the bigger question is, what could happen from this hearing? What's the best case scenario for Sean Combs here?
I mean, the best case scenario for Mr. Combs is that there's some sanctions imposed against the government with respect to the evidence that was allegedly obtained in this case. Those documents, those being suppressed out of the case. And I'm not sure, but we may even be having a conversation about dismissal later down the line, but I don't generally really think that that's going to be the case here. But some sanctions imposed on the prosecution team, removal of those prosecutors as well could be a possibility. So there's a number of things that the judge could determine to do going forward.
So again, as I said, I'm going to provide updates about what's happening in that court. We're also taking your questions. We have a question from V on YouTube. Do we know what was found in the Diddy jail cell sweep? So as I just mentioned, they found this manila folder marked legal, a notebook labeled, and it's actually redacted, an address book, and then personal effects. But as they said, the prosecutors, it was more with respect to business interest and family, and it doesn't seem to be attorney work product or privileged conversations. But we'll see. We'll see what the arguments are in court. We also have an update from court. So Sean Combs just walked in from his holding cell in the Metropolitan Detention Center. He's wearing that tan jumpsuit that he was wearing at his last hearing. He is walking fine, so he seems to be walking okay. He hugged his lawyers, sat down, and now he's just waiting for Judge Subramanian. By the way, I have to let everybody know, we weren't planning for this hearing. We were actually planning on going live on Friday because there's going to be an issue of bail. And Mauricio, you mentioned it before. That's a more tricky argument for Sean Combs because prosecutors just came forward and said he is obstructing justice from jail. He's having
he's a bad boy.
He is taking other inmates' phone privileges to contact people that are not on his contact
he's bad
list.
boy. What can I say,
He is
man?
devising a scheme to use third parties to reach out to witnesses in the case. There was also this allegation that he's orchestrating a social media campaign, not just to help his public image, but to potentially taint a future jury pool by, his son took over his Instagram and has been posting positive videos of his father. But then they also, as we know, as we reported on Sidebar, the show that I host, they actually orchestrated this happy birthday message with him and his family. They're literally wishing him a happy birthday. You hear him on the other end. He's speaking from jail. So that seems to be the trickier conversation. We weren't planning for this hearing, but what are your thoughts on the idea of Sean Combs getting let out of jail?
I doubt it's going to happen. He's not helping himself. This is not Diddy runs the city like he did before. This is, you're in prison, you're in jail, federally indicted. You had a couple machine guns with altered serial numbers at your house, like a real gangster. When a judge is thinking about whether or not he's going to let you out, he's going to take everything into consideration, including the actions that you're taking right now. I think that someone like him doesn't really understand how close they're looking. I mean, they're literally taking pictures of his legal pads. That's crazy. So they're going to listen to every single thing that you say to every single person, and then get ready for the jailhouse snitches. That's going to happen here for sure. There's going to be the guy that says that he was drinking jailhouse wine and spontaneously blurted out, I did it. That's every single high-profile case. I totally think that that's going to happen. I don't think that he's going to get a bond simply because nothing's changed. So for a judge to, go back on his ruling, a guy like him, and he starts making mistakes, does something bad, the judge is going to look bad.
By the way, the standard is much lower. We're not talking about did he have three-way phone calls and obstruct justice to prove beyond a reasonable doubt. It's just the standard of did he meet to get pretrial release, to get bail, and it doesn't seem, unless they can put forward a really compelling argument by the defense, that he's going to be able to justify that if these allegations are taken as true by the court. Okay, some questions. Question from Andy on X: is he shackled? No, he is not shackled, because the defense won that motion to have him unshackled for this proceeding and maybe presumably for future proceedings. Here's a question for you, Safa. This is a question from Erica Potter Childs on YouTube. How does an inmate have personal space rights? Now the attorney-client privilege, I understand, but anything else is fair game in jail. So I guess the question would be, what is a criminal defendant's Fourth Amendment rights in jail against unreasonable search and seizures?
Well, those Fourth Amendment rights to search and seizure are certainly limited when a person is incarcerated. But the thing is this: at the end of the day, Mr. Combs, he's facing these accusations. He has an attorney. He's always protected by that attorney-client privilege. The search and seizure rights don't supersede his ability to have that attorney-client privilege that's been granted to him by the Constitution. So there's a fine line here. Not only that, but if you've got an allegation that the government is going in doing this prison sweep, generally speaking, those things are done to prevent contraband and other things to have been found or to be in possession of those things, or to prevent individuals from being in possession of those things. That doesn't appear to be the case here. Legal documents, legal pads, notebooks don't appear to be contraband. They're not drugs. They're not going to harm anybody. So that's a very fine line in question between whether or not, those rights have been violated and so on and so forth.
And by the way, the government addressed that in their filing. They said, although pretrial detainees like the defendant retain some Fourth Amendment protections, that does not mean that those rights are not subject to restrictions and limitations. Even when a prison regulation impinges on inmates' constitutional rights, that regulation is valid if it's reasonably related to legitimate peniological interests, meaning about the prison safety and things like that. Although pretrial detainees may have some residual privacy interests that are protected by the Fourth Amendment, courts must weigh those interests against the requirements of preservation of institutional security and order, meaning got to weigh that against what's happening in the prison. All right, we got an update from court. Still waiting for the judge. Sean Combs is chatting with his lawyer, Anthony Rico, and he's seated to his left, a bow tie. Here's a question from Sindonia12 from YouTube. How is Diddy able to consistently break protocol and take the phone time of fellow inmates? So that's a good question for you, Mauricio, right? I did a sidebar on this. Is it common that you see a criminal defendant maybe taking the phone privileges of another inmate? Now, it's not alleged that he did it by force and threatened them. There was an allegation that these other inmates were getting paid for their phone privileges. What do you take away from that?
I'm pretty sure that they probably are, but imagine, he's probably got a bunch of fanboys in there. He's P. Diddy, he's famous. I'm sure I read an article that people are competing to make his bed and things of that nature. I don't know if that's true or not, but yeah, I'm pretty sure people are tripping over themselves to assist him because they figure out maybe, he can give me money, or he can, he can produce my next album for the inmates that wish to be rappers, which I'm sure there's a bunch in there. But yeah, listen, regarding Fourth Amendment, I mean, when you're locked up, that's somewhere where they do routine cavity searches. So I don't understand what people think that they have privacy rights when you're incarcerated, when they could literally give you a cavity search. That it doesn't get more intrusive than that. So I always counsel my clients, expect zero privacy. They will listen to everything. They will look through everything. They will read everything. And the higher profile the case, the more they're going to care. And I just don't understand. Like, if it's a balancing test with the prosecution, what did you get out of this? And is it worth the bad press? Because this is bad press for the prosecution. I mean, I don't think it spins well for them that they're going through all this and taking pictures of legal pads and things of that nature. In my opinion, it doesn't look good for the prosecution.
Before I go to you, Safa, on an interesting legal question, Mauricio, I have arguably the most important question that we have. This is for you. It's about the wine in the jail. How do inmates make wine in jail, Mauricio? That seems to be the question that is dominating our YouTube.
Though they get like fruit or anything, they stick it in a bag with water, and then they put it somewhere and let it ferment, and then eventually that's how you get the jailhouse hooch or whatever they call it. And they drink it, and it gets you wasted. It's popular, and it always goes in conjunction with the jailhouse snitch. The jailhouse snitch always says he was drunk on wine when he spontaneously blurted out, "I did it."
It's Food Network style. All right, let me ask you this, Saf. I want to read you. This is from the Sean Combs defense filing, one of their latest filings. I want to read you where they talk about, they say these notes are obviously privileged. I'm going to read you parts of it. Of the 19 pages provided to counsel, 11 pages are Combs' notes to and with his lawyers. These notes reflect actual conversations with his attorneys concerning aspects of his trial preparation and his efforts to be released on bail. The notes refer to defense counsel by name, include discussions of defense experts and witnesses, discuss cross-examination and credibility of witnesses, and overall defense strategy. Mr. Combs' handwritten notes covering legal strategy are now in the hands of the trial prosecutors, who hope to take advantage of the breach they committed to better prepare for the May 2025 trial, bring new charges, and argue for Mr. Combs' detention. And then they go on a little bit later to say if the warning legal on that manila folder wasn't enough, the notes are obviously legal materials that he discusses with his lawyer. They repeatedly refer to his lawyers by name. On the 14th, and then a lot of this is actually redacted, but they said that this is clear wrongdoing. The notes are replete with discussions of legal strategy. They all should have been obvious to everyone who looked at these notes, including Investigator 1, who was that investigator from the Bureau of Prisons, and the taint team and the trial team. How does the prosecution argue against that?
Well, it's going to be pretty tough. I mean, they've got to get around a number of hurdles, essentially. And to Mr. Padilla's point, this is bad press for them. You know, they have to get around how they got into that manila folder that is clearly marked legal. That's number one. Number two, then we have to go to the point of once somebody is taking photos of this, it's clearly legal material. It's clearly work product. How do we get around, saying that this is okay? And I think that's really a better question for the defense. I hate when prosecutors try to say, well, that's not privileged or that's not Brady material, when in fact it's up to the defense and the defendant to decide what's Brady material and what's important to us, because we are the ones that are crafting and framing our defense. They're not in any better position to tell us what that is. So it's going to be interesting to see how they get around this. Of course, the argument that it's not confidential, it's privileged, maybe they will disclose or say that some of this information had initially been disclosed in their disclosures, but it'll be interesting to see where they go.
Little update from court. So Sean Combs' lawyer, Mark Agnifilo, he said this to the court, we expect Alexandra Shapiro to arrive at any moment from the Second Circuit. This is another one of Sean Combs' lawyers. I have Sean Love Combs to my left. The judge said, fine, what are you seeking? Agnifilo, we want to know how his notes with lawyers came into their possession. We're going to continue to update. We're going to continue to take your questions on this. One question I have, Mauricio, is how much can the prosecution rely on, well, look, this was the Bureau of Prisons who did this. It wasn't us. And also went through a filter team, there's something in their filing that I want to read you too, where they say, even if there was inadvertent disclosure of privileged material to the prosecution team, that alone does not suggest that a defendant's constitutional rights were violated or that a defendant is entitled to relief. And they cite a case that says this after-the-fact notice of potentially privileged documents did not render the government's earlier search unreasonable. The government's review need only be reasonable, not perfect.
Listen, if you have DOJ pointing the finger at the Bureau of Prisons and the Bureau of Prisons pointing the finger at the DOJ, that's like a disaster. Like, I don't even understand, what they thought they were going to accomplish. At the end of the day, it's the government. You're incarcerated. I've never even heard of people that work in the prison taking the steps to proactively alert prosecutors of things that they found in cells. They usually don't do that. Like they're going to look for drugs, contraband, things that are dangerous. They're not going to be taking pictures and then giving it over to the prosecution. It's really bad if they're pointing fingers at each other at this point and at this early stage in the game. Like they're really stepping all over everywhere with muddy boots.
Safa, we have an update from court I want to ask you about. So Combs' lawyer, Mark Agnifilo, says he has an expectation of privacy in his legal notes. The judge said this occurred during a Bureau of Prisons sweep of the jail, but you're saying it was a pretext? Yes, 19 pages of the notes were given from the taint team to them. Mark Agnifilo says, We now, when we know enough to make out a constitutional violation, but we need to know more detail about the failures. We haven't been able to test their explanation. We need the surveillance video of the search. Two things I take away from that. One, they basically are suggesting that this sweep by, even though the government has said this was a pre-planned sweep of the jail, there might be more to it, they're saying. It was a pretext. But B, I don't know if they're even asking for some sort of relief right now, but for more information, almost like an investigation into what happened. What do you take away from that back and forth?
Absolutely. Well, first of all, to the first point, I'm a little skeptical. While this may have been a pretextual search or pre-planned, and this scheduling of this search was prior to Mr. Combs being taken into custody, everybody knows that Mr. Combs has been under investigation since last year. And I would highly anticipate that the government knew that at some point he would be coming into custody later this year or at this point in time now. So I would continue to challenge that. At what point was or when was that search determined that it was going to take place, or when was it scheduled? And then to your second point, the expectation and things of that nature, again, it's going to be really interesting here, how much they think that they can get around that. So.
No, let's talk about that. And by the way, another quick question. This is a question from Tony on YouTube. Is bond going to be discussed today? I don't believe so. I think that's still set for Friday. But going back to, this is the filing from Sean Combs' legal counsel. Mauricio, they write, the Bureau of Prisons sweep was purportedly related to removing contraband at the facility. And by the way, this was reported that they found homemade weapons, they found electronics, they found, drugs. This was all not about Sean Combs, this is about other inmates. But it says, yet Investigator 1 apparently used this sweep as a pretext to conduct a targeted seizure of Mr. Combs' handwritten notes about conversations with his lawyers. Tellingly, Investigator 1 did not report that he had identified and confiscated Sean Combs' notes of conversations with his lawyer to supervisors of the multi-agency law enforcement operation. He went straight to the prosecution team. What do you make of that, Mauricio?
You work for the BOP, you're doing a sweep looking for contraband and cell phones, and all of a sudden you're taking pictures of a legal pad. The people that work with you are going to be like, hey, what are you doing? That's completely targeted. That goes against how they operate. These sweeps are done, they're voluminous, it's work for them, and they got to get it done. For you to take the time to stop and start taking pictures of legal pads and going through his things. And then in addition to that, now Investigator 1 is taking the material that he photographed, where it's not even the norm to do so, to the prosecution, is clearly indicative that it was a target and that Investigator 1 had an agenda. He went in there to take pictures, and it's obvious. I mean, if he wants to argue that he was part of a team and he was looking for contraband, so then why did you stop and take all this time to do this in-depth search of Diddy's legal pads and legal materials? Doesn't make sense.
I'm curious to see the prosecution's response, but right now it's still based on the defense counsel's argument to the court. And to give everybody an update about what's happening in that court, and Saf, I'll throw this to you for your reaction about what's happening. So Mark Agnifilo, again, Sean Combs' lawyer. We need the communications of Investigator 1. We need to know the role of the U.S. Attorney's Office on what should be in photographs. The search was for drugs and guns and cell phones, but these are Combs' legal files. And then the judge said, just keep it on the logistics. Mark Agnifilo says, we're not sure if it was Investigator 1 who was the one doing the search, who interviewed Mr. Combs, who went to the area where his legal papers were. Once we know that, we could have a Fifth Amendment transgression. Safa.
Absolutely. Right now what the defense is doing is they're trying to get a hold and a grasp of exactly who launched this investigation, why these photos were taken, why this correspondence happened between Investigator 1 and the U.S. Attorney's Office. And a lot of these questions remain to be foreseen until we have a hearing on the issue. And right now, the defense is seeking a hearing on that issue. So we haven't gotten to that specific hearing as of yet, although they're laying the framework for why that should be taking place. And they're very valid questions. Anything that is created with respect to an investigation must be turned over to the defense, whether it's text messages that a law enforcement officer has created that goes over to the district attorney's office or the U.S. attorney's office, or any sort of documentation, photo, recording, any and everything under the sun has to be turned over to the defense. And so there's definitely a question here as to whether or not that actually happened. What was the motive behind investigator number one taking these photos, and why they got specifically directly to the prosecution team?
I have quite an update from court, and Mauricio, I'm going to ask you your response. Sean Combs' lawyer says, we may ask for dismissal of the indictment or for the recusal of the prosecution team. Judge Subramanian said, they used two portions in responding on bail, and you want me not to consider those? They need to hand over the notes. Wow. So would there be a scenario where Sean Combs' indictment could be thrown out or the prosecution team has to recuse themselves, assuming the worst, assuming this is a violation of Sean Combs' constitutional rights? What do you think?
I mean, listen, the defense is always going to ask for the star, the moons, and everything. That's not going to happen. They're not going to dismiss anything, and they're probably not going to, kick the prosecutors off. But that's the correct thing to ask for. You know what I mean? Like, there's other sanctions that are not as drastic. This could end up with, the judge giving the prosecution a lecture, telling them don't do it again. Or which probably is going to end up, I don't see the judge in this case doing something as drastic as what the defense is asking for, but he may do something. He may, give him a talking to.
And by the way, Safa, we have to be clear that this is not the first time Sean Combs' defense counsel has raised allegations of misconduct by the government. There was a whole series of back and forth and motions that the government, more specifically the Department of Homeland Security, had been leaking information to the media. They talked about leaking the 2016 videotape of Sean Combs purportedly beating Cassandra Ventura in that hotel hallway. They said that law enforcement agents were making inappropriate comments to the media. And the judge actually instituted a gag order, even made a comment, Judge Subramanian, that if it's true some of these comments were being made, it's totally improper. Now, here's an update, too, because Mark Agnifilo told the court, we don't know what the team has, we want to know, and we want the material back while this is pending. We cannot waive his attorney-client privilege. We have to be direct or aggressive. So it just seems, and by the way, so it seems to me, Safa, the fact that this hearing is happening, the judge is at least open to what the defense is saying.
Absolutely. And the judge should be, all of these things are issues that could ultimately come back on appeal. So it's best to have a thorough, hearing on the issue, making sure that everybody's crossing their T's and dotting their I's so that we don't have issues for appeal. And that could be an issue if the defense doesn't raise it, and then it could ultimately lead to ineffective assistance of counsel. I think the defense team is being very thorough right now. I think they are being ambitious, but definitely very thorough right now with addressing each and every point that they need to address to ensure that Mr. Combs gets a fair trial to the best of their ability.
By the way, we're showing everybody these courtroom sketches. You'll see there's multiple judges because this case has been in front of multiple judges before. It's now in front of Judge Subramanian. By the way, we're taking your questions, not just about the hearing. If you have questions about the overall case, we'll take them too, which actually brings me to a question from B. Denoshi on YouTube. I'll throw this to you, Mauricio. How long will this case take, and how is it going so far compared to how you may have expected? What do you think, Mauricio?
I mean, I think it could take, 6 months. It's a high-profile case. They got a lot of people on it, a lot of boots on the ground.
Wait, just to be clear, 6 months, you think the trial, or you think in the trial, or how long? Because this is scheduled for May of 2025. What do you think?
Then it should go in May of 2025. I mean, I think that they have so many people working on this that they should be ready. And I'm pretty sure that the defense has a client that's itching to get out of there. So they're going to want to go. Now, I assume that there's voluminous evidence simply because if you can't get the machine guns with altered serial numbers out of your house, I'm pretty sure that your hard drives are chock full of bad information and videos and pictures. So I'm sure that they got a lot to deal with, but I'm pretty sure if they gave them a date in May of 2025, that they're probably going to be ready to go.
We have some updates from court. We now have the prosecution's response to what's been happening. Safa, so the Judge Subramanian, by the way, this is a live look outside that courthouse. No cameras allowed in the courtroom, but we're doing our best. to update you about what's happening. So the judge says to the government, what happened here? Why were they taking photos of Mr. Combs' notebooks? AUSA Mary Christine Slavic says none of the prosecutors had contact with them. The judge said, but Investigator 1 was monitoring Mr. Combs' communications in and out. The judge said, is this a Fourth Amendment violation? AUSA Slavic, so again, this is the prosecutor. The BOP investigator works for the BOP, the Bureau of Prisons. He's focused on safety, and if the defendant is in compliance with BOP rules, he was not. If it is true that BOP gave us the info. What do you make of that back and forth, Safa?
You know, it doesn't really answer the question, in my opinion. And here's the thing. The Bureau of Prisons, the federal government, the U.S. Attorney's Office, the Department of Homeland Security, and FBI, they are all law enforcement. They are all the government. The prosecution teams are imputed with knowing and being in possession of things that law enforcement is in possession of. And I know there's a question here with respect to the Bureau of Prisons, but it definitely does possibly raise that Fourth Amendment issue because, again, why are we taking photos of these documents? Why is Investigator 1 targeted with monitoring Mr. Combs' phone calls? Now, generally speaking, every inmate's phone calls, they're monitored. There are searches that are conducted all of the time. But this seems to be a little heightened, specifically because you're taking photos of paper. Paper doesn't appear to be a threat to the physical safety of any inmate in the jail. Not only that, but it seems that there's more attention that's paid to Mr. Combs as things continue to progress. And it's very common that the prosecution team will monitor or will have those phone calls pulled. But here there seems to be just a number of things, and based on the totality of the circumstances, there's a significant red flag that's going off.
Okay, Mauricio, I'm going to go to you with a new update from court. So the prosecutor says none of the prosecution team were aware that Investigator 1 was going to be part of this sweep. The judge said, when did you become aware that photos had been taken of Mr. Combs' notes? Prosecutor responds, after the sweep. The judge said, but before the grand jury subpoena? Now, the reason that is interesting, and I believe what they're talking about, is if you go back to the government's filing, they said as part of that investigation, the government has sent grand jury subpoenas and document requests to the Bureau of Prisons for the defendant's monitored communications, including calls and emails. And then it says from those materials, the government has learned that the defendant has persisted in engaging in obstructive conduct since he entered BOP custody. We talked about that before. Mauricio, your reaction?
So they're basically saying that they're subpoenaing documents, but they're sending their investigator to get what they subpoenaed because they don't want to wait for the subpoena. Listen, it's making them look ridiculous. The longer that we talk in this particular broadcast, the worse it's going for them. What you just said really makes them look bad. You guys didn't even know where Investigator 1 was, but then again, you took what Investigator 1 gave you and you used it. Like, I don't know. It seems like no one wants to take responsibility for this PR nightmare that they created themselves. And at the end of the day, what did they get? And also, before I forget, they're taking pictures of a legal pad. That's kind of already like, it's a legal pad. Like, people would say you should have, the thought that maybe there could be some writings or notes regarding your case on a legal pad. So that's something else that could be looked at. But as far as I'm concerned, a prosecutor saying that they didn't know that Investigator 1, it doesn't seem true at all.
Well, there is a response where, the prosecution is saying it seems the defense is not being totally transparent because here's another update from court. The judge said to the prosecution, so there's nothing else? The AUSA Slavic, the prosecutor said, Mr. Agnifilo says the defense team does not know what the paint team has, but we made a production to them last night of everything, not just the 19 pages that were passed to the case team. So Safa, they're basically saying that, defense is saying they want to know everything that was taken. They want to know everything. We told them everything that was taken or everything that was produced.
You may have finally disclosed it because you knew that this hearing was coming forward today, but this should have been done long ago. Not only that, but I think at this point, what's important is to get Investigator 1 into that courtroom, put Investigator 1 on the stand to make a determination as to how he was directed to get these documents, who he spoke to, how he came to the decision to photograph those documents, and so on and so forth. So I really think that's where we are, is having Investigator 1 come on the stand. That's going to be the answer to all of our questions.
I have a question from Susan LeBlanc on YouTube. So no cameras through the whole court process? Unfortunately, no. We do not allow cameras in federal court, New York federal court. I could talk forever about how I think that's a mistake. I think there should be cameras in the Supreme Court as part of transparency. I think it's better for the public to see it. We get to see the evidence ourselves. No more rumors, no more speculation. It's a good thing to see the judicial process play out, but unfortunately, I am just a host on Law and Crime.
I done the mob
Not the
here.
chief judge anyway.
Mob never had one
Let's
of
see where this goes. Anyway, we got an update from court. Prosecutor says, these materials were obtained as part of the government's covert ongoing grand jury investigation. The judge responded, is it standard procedure to photograph notebooks rather than take them so it could be known they were taken? Prosecutor said, I don't know. Who wants to answer that one?
Just a really shoddy investigation. Again, and to Mr. Padilla's point earlier, is if you issued grand jury subpoenas, then why do you have to have investigator one go in and photograph specifically what you seem to be looking for? It doesn't make sense. It's really shoddy. It's really fast and loose. I don't know what the prosecution team is.
Let me ask you this, Mauricio. Let's say, for example, you tell me, could this affect what the government said they found in terms of obstruction? You know, we have the phone calls, we have these third-party calls, we know what Sean Combs has been doing behind jail, and this is further evidence of obstruction. He shouldn't be allowed in. Is there anything that could happen today that could affect his chances of bail on Friday?
I don't think so. I think they're completely separate. One thing is whether or not he's a flight risk. One thing is whether he's a threat to the community, as a whole. And the other thing is the prosecutorial misconduct that they're engaging. I don't understand how you say it's a covert grand jury investigation, but you started off saying that it was a random sweeps. Like, which is it? It can't be both.
Well, they could say it said we were continually investigating what he was doing behind prison. And look, this sweep happened. We didn't order the sweep. They ordered the sweep, and it just so happens during the course of the sweep, bada boom, this came up.
Right. So the covert investigation was investigator one in with everybody else that was conducting the random sweep, and then went straight to Diddy's cell to photograph. So that's targeted. That's the definition of targeted.
I want to read.
In my opinion.
That's fair. That's fair. The judge might see it that way. So this is an update from court. The prosecutor said, we are not required to notify the defense of our ongoing investigation of criminal conduct. We receive these materials in an appropriate channel. Whenever we get new information, if there's reason to believe there's privilege, it goes to the filter team. Safa, walk me through that. How, if you goes through the filter team, is everything okay?
Absolutely not, because who determines what's appropriate with the filter team? You're asking the government and the police or law enforcement to police themselves. There's no outside check and balance, from a defense or from any other administrative board to say, yes, provide us with that documentation. We, as an outside, source or organization or agency, will then determine if it's appropriate, if it's confidential and privileged or anything like that. So essentially, it's the government trying to police themselves and cover up some things that they maybe inadvertently or targeted and wanted to get in possession, and is now in their possession.
Well, I have another update from court on that. And by the way, if you have any questions about what's happening today, if you have questions about the case in general, please throw them on YouTube. We'll address them here on air, live look at the courthouse. So Mauricio, the Judge Subramanian, says if they were verbatim notes of his meetings with his lawyers, how would you know without asking the defense? And the prosecution responded, our filter team does a serious job. This investigation was covert. We had a lot of information before charges were brought. Thoughts?
Who is this filter team? Like, who are these people? Like, I really have never worked in a case that had a filter team. Today was the first time I've even heard that the term. I'm assuming that it's prosecutors or people that work at the prosecutor's office. I don't know who they are, but I, as a defense attorney, don't trust them. They're probably part of the government. So I really don't understand why, if you just label them filter team, that they're not part of the government, part of the prosecution, and part of the problem, of the ongoing problem.
Yeah, I'm trying to look in their last filing if they give a description of who the filter team is. There is this interesting part. They says, as is consistent with the practice in this district, the filter teams review segregated, potentially privileged materials as evidenced in the redactions contained in the photographs. This approach is eminently reasonable. Here, where the photographs related to the government's ongoing covert grand jury investigation, the government had no obligation to seek defense counsel's view of the privilege determinations made by the filter team. Saf, I'll give you an opportunity to respond to that.
Yeah, I think I did review some of the documents earlier on the case, and I think that the filter team is a team that is assigned and works in the Bureau of Prisons. So they're determining whether or not it's confidential privilege or attorney-client privilege. Again, expecting the Bureau of Prisons or the government to police themselves. And there's a question there because it doesn't appear that any defense attorney has the ability to say, yes, this is attorney-client privilege, or even the judiciary or anything like that. So that's a significant question. It also brings to mind, and for example, when we have wiretap cases and there's been a wiretap on a phone for maybe a year to 2 years and they've been listening to our clients, but then when the client calls us as their defense attorney, the police themselves determine, oh,
Hey, you. Yeah, I'm talking about you. Hey, man, if you hadn't, man, you need to go ahead and get this book, man. You know what I'm saying? By yours truly, Charles Malone. Hustle forward, not backward. Mama, I made it. You know what I'm saying? It's available on Amazon.com. It's available on our streaming platform for as the where the books go. You can get it at Barnes and Nobles as well. I got a description on the back tells you a little bit about who I am. You know what I'm saying? If you want to go into detail or whatever, for the low price of $9.99, man. We got Black Friday coming up, so you'll be able to get this book. You know what I'm saying? My autobiography. You know what I'm saying? Hustle forward, not backwards. By yours truly, Charles Malone. Thank you. And also, if you had, man, you know what I'm saying? You need to get you some of this Rogue Energy drink for your thirst needs. If you get like, if you feel it down and you need some feeling down and sluggish, man, this Rogue Energy drink, man, is pretty good stuff, man. I've actually tasted myself by going and using the QR code Malone TV that's on the front of the screen. Yes, use Malone TV QR code that's on the front of the screen to get like 10% off on your first purchase. With that being said, we're gonna get back into the event, man. This video.
odd, really, in my opinion, inappropriate ways of monitoring these important correspondence. So
We have a question from YouTube. This is Pam from YouTube, excuse me. Mauricio, I'll throw this to you. How would anyone know if it's legal talk on that notebook or that it's him trying to get illegal messages out to others? Why would they go on faith with a high-profile criminal?
Why would they go on faith with a high-profile criminal? Like, meaning justifying taking pictures and looking at it? Listen, at the end of the day, what did they think that they were going to get? Information regarding obstruction, or it seems to me that they already have them busted doing a bunch of incorrect things, including three-way calls, including trying to activate social media to affect the jury pool. Like, if you got them cold busted on certain things, don't muddy the waters and do this ridiculousness, because what are you gonna have? You're gonna have a day like today where you're in court trying to explain your tomfoolery to a federal judge, and it's not paying off dividends for them.
So we are providing updates from court. I have a few more that we want to talk about. Safa, so apparently the prosecutor said, I understand there's a dialogue between the defense and the filter team. I'm not part of that. The judge says, I don't understand that dividing line between the covert investigation and discovery in this case, given that the defendant has been charged. The Prosecutor also said our grand jury investigation is ongoing into conduct that has not currently been charged. We have multiple ways to get information that are not obvious to the defendant. We are not obliged to inform them. They have no authority for that. Safa.
Here's the thing. They can have an ongoing investigation all they want to, but Mr. Combs has already been indicted, and post indictment now, and as we head through the stages of the proceeding, there are documents that they are generating themselves that could be discovery and are required to be disclosed. They also are what we in the law call Brady material, could possibly be exculpatory in nature, or are things that the defense team is going to want to investigate themselves.
Meaning evidence that would show he's not guilty.
Correct. And Brady versus Maryland, it's one of our big cases in the legal world. And so essentially what the government is doing is continuing to now make discovery, in my opinion, as the case is progressing. You know, they may be considering other charges, maybe witness tampering or whatever they determine to do, and that's fine. But again, they have muddied the waters, to use your words. And here we are now where they've created additional discovery, additional things that are required to be disclosed, but they want to keep it close to their chest. It's not okay.
Okay, well, you tell me if this is okay, Mauricio. The judge said, I want to be cautious since some of this is sealed, but is any of this privileged? And the prosecutor said, the notebook was labeled things to do, not attorney-client. They suggest they were meant to be in the folder marked legal, but self-labeling is not enough.
Things to do when you're indicted and sitting in jail it's pretty assumes that things to do have to do with your case. I mean, that's pretty much
fair?
the main.
Is that fair? Maybe it's, I don't know, do 1,000 crunches today. Make sure to call mom. I don't know.
Yeah, but I'm sure that in that notebook, things to do, and you have this looming indictment is going to include some things that have to do with your legal defense, you know, and it's not okay to just go in there and start photographing things and trying to get an upper hand. At the end of the day, I mean, they have a pretty strong case. I don't understand from my perspective. And this whole thing smells like a superseding indictment. People like his son, the feds love to indict your relatives. So if they got Diddy's son doing inappropriate things, that for them is, they love it. Because nothing is worse when you're sitting in prison than all of a sudden they indict your son or a relative or a close friend.
I mean, there was an allegation put forward in the most recent bail motion by the government, Safa, where they basically say Sean Combs is having his family doing his bidding for him. So if it's clear there's a grand jury investigation going on. It seems more likely than not there could be more charges leveled against Sean Combs, but possibly others, right?
Yeah, absolutely. And I think that's the way that the government is trying to, of course, frame it. I think one of the important things here and what everybody is kind of on edge about is the possibility of witness tampering. And so whether it's Mr. Combs or anybody that's close to him, including his family and his children, really have to be mindful of what they are putting forth to the public, who they're speaking and communicating to, and things of that nature to avoid any subsequent charges that could come about. That's one thing. The other thing I'm going to say is, and I think that the government alleged in the bail application or in the opposition that Mr. Combs' son was using social media to allegedly taint the jury. And one of the things we have to remember is that although a defendant's been charged and they're incarcerated, it doesn't stop the real world and life from going on. If a family wants to celebrate their birthday or their loved one's birthday, they should be able to do that. Mr. Combs, of course, is a high-profile individual who's got tons of followers on social media, and there are people that still do, believe in him and enjoy his music and all of those sorts of things. And so what I'm plainly saying is that Mr. Combs shouldn't be robbed of the ability, or his family shouldn't be robbed of the ability to celebrate him in whatever way they see fit.
I always found that to be a little bit of a stretch, that argument. Well, he's posting birthday videos. His son has taken over his Instagram and is posting messages about, posts about his rap career and music videos. I think that in of itself might be a little tenuous to say, oh, that's going to influence a future jury. We don't even know who the jury is. It's not like trials tomorrow. But also, he might have a right to change the public narrative about him nonetheless. He's a public figure. That one always felt a little rough around the edges. There would be a different allegation where they were saying that and this is something that I thought was really interesting, is the prosecution essentially identified one of the key witnesses in this case and made the allegation that Sean Combs had pressured her to make a public post. This was before his arrest, that basically said one of the allegations in one of the lawsuits was false. So that would be a little bit different. Okay, I have another update from court. This is from the prosecutor. I think, again, talking about what these
Smash that
materials
like
are,
button,
or
man.
what we're
Share the
seeing.
channel. Smash
These
that like
include
button.
action.
Share
So
the
again, I
channel.
think this is about things to do, Mauricio. I'll throw it back to you. Prosecutor says these include action items for non-lawyers. That's not privileged. Their information about family members' birthdays, also not privileged. We point to the Lumiere decision by Judge Rakoff. We are happy to engage with the defense. What are they talking about?
I mean, it seems to me that they're talking about whether or not the actual information is privileged or not. They cite case law. The problem is that most people, including lawyers that do this for a living, have never seen this type of behavior. Like, they're going out on a limb for everybody, the legal community, the community at large, and the public is looking at them saying, really, guys, you guys are in there photographing, his manila envelope that says legal on it. You're going through his legal pads. So the prosecution can cite whatever case they want. At the end of the day, the public is going to think whatever they want. And as of right now, it looks like if they're really trying to find evidence that they need, it makes them look like needy, which I don't even think that they are needy. I think they have plenty of evidence, but they're greedy. They want more. They always want more. And I've always predicted that at some point, I know Diddy's was active in politically. I think they're going to go after some of his political friends.
I don't know. That's always the next game. Who are they going to go after next? I don't know. We'll see.
Yeah.
But I tell you what, talking about looking ahead, there's a mention of the bail argument on Friday. So, latest update from court right now. The judge said, how about agreeing that I should not consider these two excerpts in your opposition to the bail motion? And the prosecutor says, I think that's right for the bail argument scheduled for Friday. The judge said, what about putting them in a vault? They are inspirational messages. Kind of hard to talk about what they're referring to, but it seems to me at the very least, Safa, that there might be parts of the bail motion that I mentioned that the prosecution can no longer argue for Friday, maybe?
Yeah, so I think there's an allegation that's been made by the defense here that whatever information had been obtained by the Bureau of Prisons and was ultimately turned over to the U.S. Attorney's Office was used at some point during some bail application. Which one, I don't know. So I think what the judge is essentially saying here is in preparation for tomorrow's bail application, which they possibly have filed their papers in advance of that, request in opposition and the prosecution's opposition to the defense bail application, that some of the information that was obtained through the search and was used in that application will be kept out or stricken. So the judge will basically instruct himself, well, I'm not going to consider these things. We're going to act as if they don't exist.
Maybe it's about that whole section about the birthday messages. Maybe the judge is saying you can't use that stuff anymore in support of your opposition to bail. I'll tell you what, we're going to take a quick break. When we come back, we have a lot more to talk about. I think I have to sign off my guests. Yeah, I have to sign off my guests. It was great having both criminal defense attorneys, Safa Robinson Ferrer and Mauricio Padilla. Look, you guys are fantastic, but both criminal defense attorneys, I saw a little bias here, but it's okay. You both were terrific. Thank you so much for coming on. Really appreciate it. We'll take a quick break. We'll come back.
So what basically going on right now is he's in court. Let me get my mic. Diddy's already in court, pretty much. So they just basically pretty much waiting on to see what the judge say far as this hearing goes. As this hearing goes, and he got he got a bail hearing on Friday. So therefore, right now, they were just going over all the evidence and paperwork or whatever, for this hearing or whatever, pretty much, to get prepared for Friday or whatever. from my knowledge, from what he was just saying, from from Law and Crime. So we're gonna get back into it and see what's going on. And we're gonna stay updated to on everything as what's going on. So make sure you hit the share and hit the like button. You know what I'm saying? Share, comment, subscribe. Get down in the comment, tell me what y'all think, man. You know what I'm saying? We're finna get back into it. Just a moment. If you hadn't subscribed to my YouTube channel, man, and my Twitch, go ahead and do that. So his lawyers will be probably coming out that door in a little bit and doing a press conference, basically letting us know what's going on. Make sure you smash that like button, comment, get down, drop down in the comment, tell me what y'all think about this live video, and also share if you haven't. Also subscribe to my YouTube and my Twitch. And nothing like New York City. Nothing like New York City. Frank Sinatra. New York, New York. Hey y'all, who said that? Who said this right here? Jot down in the comment. Who said it? Ain't no party like I did it party. LB. He said that. Mhm.
All right, welcome back, everybody. I'm Jesse Weber. We have a special live coverage right now of the Sean Diddy Combs case because what is happening right now is there was an unexpected hearing that was planned for today. It was announced yesterday, where Sean Combs' defense attorneys are accusing the government of violating the attorney-client privilege, violating his constitutional rights, saying that there was an improper seizure of materials taken from his jail cell during this pre-planned, although the defense says it was really done for the pretext, but this pre-planned sweep of the Metropolitan Detention Center where he's currently being housed. And the question is, were there materials that were improperly photographed or taken or seen? Was it put through a proper filter team? Why does the prosecution have this now? Is this a violation of Sean Combs' rights? What could be the repercussions for it? We heard earlier this defense counsel telling the judge, Judge Arun Subramanian, they want the indictment dismissed. They want it thrown out. That could be a potential violation for this. Now, I want to give you some updates from court because a couple of things. One, no cameras in court, but we are providing you updates about what's happening there. We have live reporting. Speaking of which, our very own Elizabeth Milner is going to be coming out of that courtroom. She's in that courtroom right now. She's going to be coming out and giving us a live report about what she observed in that courtroom. This is a live shot about what's happening outside the courthouse. But let me tell you a little bit more about this as the judge is weighing about, were there privileged communications? Was there attorney work product that was improperly seized or photographed? So these are a couple of updates. The Judge Subramanian, says, what if an individual had counsel paid by another? The prosecutor in this case said the payment, not privileged. And if it's about paying off a witness, that is what we are investigating. These notes refer to individual 2, a non-lawyer third party. It's on his to-do list. His to-do list was one of these papers or these folders that was found in his jail cell. And remember, this ties into the ties into the prosecution's argument that Sean Combs should be denied bail. That there's going to be a hearing on that on Friday. One of the actors behind bars, he has been trying to influence witnesses. He has been improperly communicating with people. He has been having family members and others doing his bidding to influence the case. So moving on, the judge said a defense lawyer can investigate potential witnesses. It would be malpractice. These are about the defense for witnesses is a closer call if it falls in work product. The prosecutor responded, the person tasked is a non-lawyer, meaning there's no privilege there. The prosecutor said on October 18th, the defendant told a family member to work with a non-lawyer to find everything about victim 2. And this non-lawyer, individual 2, is not identified as part of the defense team. Judge responded, what about turning over the surveillance video? The prosecutor, in another response, said, we are opposed. There is no authority for that. Judge said, I noticed that. Mr. Agnifilo, this is Sean Combs' attorney, they want to work with you to try to resolve this. Agnifilo seems to laugh, and then the judge said, you may not agree, but we'll discuss. Agnifilo says, we don't want to give them insight. Agnifilo says, all the legal pads say legal. What the government is saying was searched is just not accurate. The judge said, wait, you're saying the photos taken from pads marked legal. Can you show me? And then Agnifilo apparently walks up and hands Judge Subramanian a notepad. Agnifilo then says, when we visit him in jail, we have lists. Everything in these pads are things we discuss. Trial strategy, who we should speak to undermine a witness's credibility. We discuss everything with Mr. Combs. This is a sweeping racketeering case. I want to bring back in criminal defense attorney Safa Robinson-Frere. She was kind enough to stay with us. And we're also joined by criminal defense attorney Natalie Whittingham-Burrell. Great to have you both here. Natalie, I'll start with you. As you heard a little bit about the updates here, what do you make of this? Did the government engage in wrongdoing?
So I think I would personally...
Natalie, I can't hear you. I don't know if we're working on the audio. I don't know if you're muted. I'm trying to work it.
Not muted.
There you go. Hey,
okay. Well, I am of the opinion that I would need to see the work product itself, or the materials to see But certainly here, the prosecution did not take, I think, the necessary steps to safeguard attorney work product communication and information, because even if they've given it to this so-called clean team, they have seen it. The police have seen it. And so there is a possibility here that they did violate his right to attorney-client communication and privilege. It's very, very possible, depending on what was in those materials. And things that are marked attorney-client, work product are clearly attorney-client work product, and they should not be looking at it.
And Natalie, let me follow up with that, because Mark Agnifilo just said, we are studying this man's life for our bail application, his charity work. This is not a single day, a single event case. We spend time on every nook and cranny of this man's life. So it seems to me they're saying, you should consider, government, everything that's in his jail cell as part of his criminal case. You don't have a right to see it. Am I understanding that correctly, Natalie?
That might be what they're saying, but it's a bit more restrained than that as far as the federal rules are concerned. And yes, for the bail application, his life is very important. However, conversations with third parties, with individuals that are not a part of the defense team, do not fall under attorney-client work product, nor is it necessarily attorney-client work product. Not that the prosecution is alleging this, but for the attorney to assist the defendant in committing some type of crime. If they could allege that, Sean P. Diddy Combs is trying to obstruct justice and he's using his attorney's communication in order to do that, that's no longer privileged communication, because we cannot participate as attorneys in criminal activity. But let's say that that's not what the material is, and it goes to his case, then yes, that is privileged material, and they have no business looking at it in any regard. They have no right to look at it.
Safa, another update from court. Combs' attorney said, Mr. Combs comes out and reads us his to-do list. That is privileged. The 19 pages include things we have said to him. These are the notes that were allegedly taken by the government. The name of a potential witness, a retired doctor, now they have that. This is the heart of attorney-client. Safa.
Absolutely, and I agree with them. And to my point I said earlier was, at the end of the day, who is in the best position to determine what is attorney-client privilege or what is attorney-client work product? The prosecution isn't. It's up to the defense to say, these are our witnesses, these are the avenues that we are exploring, and that's up to us for our defense case. So the prosecution isn't in the position to tell us or to tell his defense team what is privileged and what is not. And if anything, have the hearing on the issue and let the judge make the determination.
It's interesting because, Natalie, and by the way, if anybody has any questions about this hearing, has questions about the overall case, submit them on YouTube. We'll answer them for you on air. Natalie, it seems the defense is saying, particularly when it comes to this search of the Metropolitan Detention Center where Combs is being housed, that this sweep, this raid that was pre-planned, and it was looking for contraband, and they found homemade weapons, they found drugs, they found, all these different things, electronic devices. It seems what the defense is suggesting, and this is a pretext to really search what was in Sean Combs' jail cell. You think that's a little of an extreme position?
It's not extreme at all. I think it actually is a pretext to search his jail cell, because there's allegations before he was incarcerated that he was tampering with witnesses. Of course, they're going to look and go see whether or not he's still tampering with witnesses. That's not far afield to me at all. What ultimately matters, though, is that it doesn't matter if it's a pretext, because no person incarcerated has a Fourth Amendment right to privacy that you would have in your own home. You just don't have that right. However, the attorney-client privilege communication, that is sacrosanct and that is protected, right? So if they use this pretext in order to get into attorney-client communications purposefully and did not take the necessary safeguards, then they've committed a massive ethical violation. But as far as whether or not they need a reason, there doesn't need to be a pretext, because they don't need a reason to search his cell, because he has no expectation of privacy in his cell.
Interesting. So, Safa, let me go to you with this. We have a question from Benoit on YouTube. I'm wrestling with this as well as what we can expect by the end of the day. But the question is, from Benoit on YouTube, is it possible the judge makes a move today with this situation? It's kind of like, I'm debating with it because it seems like the judge and the defense are saying we need more information. It also seems like he's saying, defense counsel, can't you work with the prosecution on this? Do you think we're going to get a decision on this today?
We may not get a decision on this today. The judge at this point in time is exploring, what actually happened, what remedies are available to him to rectify this situation. And so we could get a decision today. He may reserve on that decision. We just don't know at this point.
And what would that decision be?
Whether or not what's included in those documents is a breach of that attorney-client privilege and relationship. And if so, what sanctions will the judge impose?
And that leads me to the next question we have, Natalie. This is from Kwang Lee on YouTube. There's absolutely no way Diddy gets a dismissal due to this screw up, right?
Prepare yourself, guys. So it just depends on the facts of the case. And the court will likely do a good faith analysis, meaning, was the prosecution intentionally attempting to intercept attorney-client privilege communications, or were they genuinely looking for contraband and just happened to come across these things, right? Or were they just doing a search, hoping to find evidence of witness tampering and not anticipating finding so much attorney-client communications? But I want to be extremely clear here. Dismissal of a case for interception and misuse of attorney-client privilege communications is a rare remedy, but it is an available remedy. It can happen. Not saying it's going to happen here, but I'm saying that this is extremely serious, needs to be investigated further, and that is a potential thing that could happen, that the case gets dismissed.
Can I ask you about that? You mean a case can get dismissed where the judge says, prosecution, I can't believe you did this. You tainted this entire case. It shows what you're about. Dismissed. Almost, by the way, like happened with the Alec Baldwin case. But is it that, or is it another in the examples that you've seen in the past, where because of an attorney-client breach, or because of a violation of a defendant's constitutional rights, a key piece of evidence can no longer come in, and then the whole case falls apart? Because I think the problem with the second one is, even if the government can't use anything that they found, it doesn't affect the racketeering charge or the sex trafficking charge or the transportation engaged in prostitution charge. So it seems like what you're saying, and correct me if I'm wrong, that because this would be such an egregious error, the judge would say this taints the whole case. I mean, correct me if I'm wrong.
So here's the thing. That is a potential outcome. Another potential outcome is a piecemeal redaction of whatever it is that they intercepted. But we have to remember this. Under the Sixth Amendment, he has a right, every defendant has a right to communicate with their attorney, to vigorous defense, and that is a due process right. It's the way that you receive a fair trial. The prosecution can so much interfere in that right by intercepting those communications where they shouldn't even be seeing them, that he no longer gets a fair trial because of how deeply they got into his case. I'm not saying that's what's happening here, but that's why I said it's a rare remedy, but it does happen that you have so far infringed on his right that it's impossible for him to receive a fair trial. It doesn't even necessarily matter the value of the evidence. And that's why the courts will get into an analysis of whether or not this was something that was intentionally done by the prosecution, that for a strategic advantage, versus something that was done maybe accidentally or negligently.
Sure. I understand that. Yeah. And I think that's a good distinction to make. Safa, we have an update from court. I want to read everybody. The judge says, I'm looking at the case you cited, Ms. Slavic. This is the prosecutor. Are you familiar with it? AUSA Slavic says, I'm not, Your Honor. And then Sean Combs' lawyer, Mark Agnifilo, says, Ms. Garrigo, something to say. That's another one of Sean Combs' attorneys. And then Attorney Garrigo says, they say there's a covert grand jury investigation, but there's the current indictment. From there, prosecutor says, we're talking here about 11 pages of notes, not a stack. None of those notes are legal. The judge says the notes themselves are not legal, but that page was in a legal pad that was marked legal. Prosecutor says it's not clear when defendant wrote that on. What do you take away from that?
It doesn't matter. At the end of the day, these notes were located on a legal pad, not a regular notebook, but a legal pad. And I believe it was located inside of a folder that was also marked with clear lettering legal. And as a result of it, it should have been treated as such. How they even got to those additional pages is a question. How do we get there when this is clearly something that could be work product, attorney client product, or communication? And are you just going to dismiss the first page and then go to the next ones and assume that it's not? I can't make sense of that.
You can, I want to read you a question from one of our viewers, Natalie. It's from Dougie Jones on YouTube. What is more important, the crimes Diddy is accused of, or taking pictures of pieces of paper?
What is more important is everyone's constitutional rights. So the thing that I tell everyone is that your constitutional rights were built on the back of bad guys. Miranda was someone who confessed to a crime, right? He did it. He confessed to it. But we all now have Miranda rights because he wasn't properly advised that he didn't have to under the 6th and the 5th Amendment, right? We have the right to walk away from police officers when they stop us and frisk us. We don't have to stay there and be stopped and frisked. You have Terry to thank for that. Your right to have an attorney free of charge if you can't afford one. You can thank Mr. Gideon for that. He was a bad guy. He was convicted of crimes. Sean P. Diddy Combs might be an allegedly bad guy, but if you don't uphold everyone's right to counsel off of the back of these bad people, you don't get your rights. So later on, if you are alleged to have done something that you didn't actually do, and then the police or the state is able to go in and look at your letters back and forth to your attorney and use them against you, then you would have lost your rights because of a case like this. That's why this is more important than that.
Very, very well said. And let me just add one more thing, particularly in high-profile cases, particularly where you have defendants who are accused of egregious conduct. I will say it becomes, it's important in every case, but for those who believe that he's automatically guilty, for those who believe it's just we have to go through the pro forma of a trial, the last thing that you want is a criminal defendant's rights to be violated in some way pre-trial because, and correct me if I'm wrong, what could happen is they get convicted, they have grounds for appeal, this conviction gets overturned, you got to start the whole process again. It's not even necessary you have a second trial. It won't be as strong as the first time around. So anybody who really wants justice in this case, who already thinks that Sean Combs is guilty, just keep that in mind. Now, I want to actually go to you, Natalie. One more thing. We have an update from court. This looks like we have now a timetable. So the judge says we have a bail hearing on Friday at which I will not consider these materials. In terms of running down the privilege issues, that can take weeks. Any issue with that time frame? Sean Combs' lawyer says no. The judge says I'll issue a schedule. Sean Combs' lawyer says if they are intending to seek a superseding indictment with these notes, the judge asks the prosecutor, and the prosecutor says, just to be clear, the filter team can keep the notes. The judge says if they're not involved in the grand jury investigation or this case. Multiple points there, Natalie. You talk about what you want to hit first.
Yeah, so first of all, off the bat, I can't tell the judge's tone of voice, but immediately there's a sanction on the prosecution. And that is the prosecution is seeking to oppose Sean P. Diddy Combs' release from jail because of alleged witness tampering. However, they got to that witness tampering by intercepting attorney-client privilege, and so they cannot use it. So that is basically a ruling that, at least for that bit of information, it's a possibility that that was attorney-client privilege. They didn't take the necessary safeguards, and now they can't use it. Doesn't mean Diddy's going to get released, but it means it's a lot better for the defense that they cannot use that. We also now know that there is a potential for a superseding indictment, likely adding on charges of obstruction of justice. But if it's found that that indictment was generated as a result of the violation of attorney-client privilege and work product, then more than likely that indictment is not going to stand. They might have killed their own case by the way in which they gathered this evidence. So those are the things that pop up in my mind.
Saf, I'll give you an opportunity to respond if you agree with Natalie, but I'll also throw this out. We have a question from Tiffany Marcinak on YouTube. if not a dismissal, which doesn't seem to be what the case is, I wonder if this is used to grant him bail. So again, the question is, how does this affect Friday?
Definitely. So I 1000% agree with Natalie to answer your question first and foremost. To the issue of bail, I don't think that these things are going to be considered for bail. And in fact, it appears that the prosecution tried to use some of this information in opposition to Mr. Combs' bail application, but the judge seems to be striking certain parts from that opposition, or is not going to consider those parts of that, those documents or whatever they might for the bail application.
Big update from court. Okay, so this is interesting. First, the judge says, Sean Combs' lawyer says they should preserve the video. The prosecution says fine. This is the part I want to address. So, Natalie, the judge says, what about the Jeffries case in Eastern District of New York? Talking about Mike Jeffries, who was arrested on sex trafficking. The judge says the government released him on a $10 million bail. This is in the Eastern District of New York. Be prepared to address the difference there. And the prosecutor says it's very different. That was one of the arguments, Natalie, that Sean Combs' defense team raised. Another high-profile individual. Why does he get $10 million bail and my client doesn't? Wow, the fact that the judge might be entertaining that.
Yes, I think that's very interesting. I don't know with the Jeffries case if there's any allegation of witness tampering. We know that before this raid and the interception of attorney-client work product privilege, the prosecution had already raised that Sean P. Diddy Combs was reaching out to witnesses, but that was a bit more ephemeral. They couldn't exactly say what he was saying to these witnesses, and he had not yet been indicted. And now with the judge saying he's not going to consider the new information, they are going to have to distinguish him from the other case. Why is that important? Because it's important to have fairness across the board, right? So similarly situated defendants charged with the same thing should have similar bail and release conditions. There shouldn't be differences if they're pretty much the same. So that's very interesting. And I'm think it's going to rise and fall on the previous allegations that were made of witness tampering.
So I want to let everybody know that the hearing is over. The judge is now going to see both parties on Friday for that bail hearing. We plan to cover it here on Law and Crime the very same way, but I don't want anybody to go anywhere because we're waiting for Elizabeth Milner to come out of that courthouse, give us an update about what she observed inside that courtroom, including what she observed of Sean Combs. Did he make any statements? Did he say anything? Did he look in a certain direction? Because something's still probably going on in that courtroom. He might be, maybe he said something or motioned something to his family. It'll be interesting to hear. And also things that weren't picked up during the course of this these live updates. But what's also interesting is I don't think we're going to hear any press statements, Safa, right? I don't think we're going to hear anything from the prosecutors or the defense because there's a gag order in place, right? There's only so much that they can say. I mean, it's about not disclosing certain information about the case. It's not about, they also can't reveal grand jury material. Do you anticipate we're going to hear any pressers after this?
I don't think so. And if anything, I don't think that we're going to hear from the prosecution. And I think it's best at this point for them to keep quiet, considering the tire fire that's been created and why we're even having this discussion today. That's number one. Number two, if we hear a statement from Mr. Agnifilo, that is a possibility. But right now, I think it's best that everybody just sort of takes a pause and kind of keeps quiet, especially with the defense. They could be looking at a huge one for their case, and they don't want to say anything or do anything that could potentially jeopardize what's going to come down this coming Friday or in the future for their case.
Got some questions as we wait for Elizabeth to come out. The question from Cole on YouTube. Why did the judge consider the Jeffries case before? I guess it's why didn't the judge consider the Jeffries case before? I would say the timing of it, because Sean Combs had already been denied bail twice. Then Jeffries gets arrested and charged, and this issue hasn't come before a court yet. There was Sean Combs' team was actually appealing this to the Second Circuit Court of Appeals, paused that in order to now argue this in front of the most recent judge overseeing this case, Judge Arun Subramanian. So again, he seems to be the first judge to handle this issue and has already commented on it. All right, so I have a question for you, Natalie. This is from Bright Essen on YouTube. So because it seems like he got a relatively early trial date, does that mean his case will be resolved much more quickly than usual court cases of this magnitude, or will it take years and years?
It will take years and years, but I'm doubtful given We're just in the pretrial release stage. We haven't even gotten to motions, right? I doubt this case will be tried on the currently set trial date, hopefully not years and years, but these prosecutions do take a long time.
May of 2025, which is an interesting argument, Safa, because in the prosecution's most recent filing on bail, they addressed one of the defense's concerns, because the defense said, look, he needs bail. He needs to be out because the MDC, the Metropolitan Detention Center, is not adequate for him to prepare for trial. It's not adequate for him to review all the discovery in this case. And the prosecution responded, no, it's adequate. He has a separate room. He can communicate with his lawyers. And by the way, if he needs more time preparing, let's adjourn the trial date. He's the one who wanted May 2025. Why don't we push it out then? What do you think about that argument, Safa?
Well, Mr. Combs and every American has a constitutional right to a speedy trial. That's number one. So that's why we're seeing that trial date that's been scheduled for May 2025. So that's the first thing. Not only that, but it's always easier for us to meet with our clients and confer and all of those sorts of things with our clients out of custody. Yes, they have a room, they have all of these mechanisms and means for us to meet and discuss our case with our clients, but there's nothing like having your client come into your office or into your boardroom, throw a body camera on TV or throw any kind of footage on the TV and be able to look at that themselves. And sometimes our systems aren't as well equipped when we have to transport our computers and recordings and all of those sorts of things into the jail. More often than not, it's always easier, and it's definitely best for us to have our clients out of custody as we continue to prepare for trial. And it makes for a more meaningful defense when we're able to do that.
It is interesting, Natalie, thinking about this issue of bail on Friday, which I think is going to be fascinating. I've been following it for weeks. Because if you take the prosecution's arguments as true, that he has been improperly contacting people from jail, that he's been using other inmates' PAC numbers to make phone calls, that he's been engaging third parties to reach out to witnesses, the question becomes, why should we trust him on the outside in what would essentially be a home prison, 24/7 monitoring, visitor logs, only family members would show up? Because the prosecution is saying he's enlisting family members to do his bidding. He might get the security team to bend the rules a little bit. You think it's a stretch for him to make bail on Friday?
It's going to be difficult for him. He still remains a flight risk, just as a function of his wealth. And he does have particular allegations against him. We can't really think about the ones from his jail cell. The other ones, though, that he has massive power and influence over people. And so the government's best argument is that the only way to control and stop that so that they can have integrity in their case is to keep him incarcerated so that they can legally intercept his communications. Because like I said, he has no right to privacy. All of his phone calls will be intercepted. So that is the strongest argument for the prosecution. But then on the other side, did the prosecution kind of get that up by overstepping their bounds and intercepting his attorney-client communications and making it so that he cannot safely prepare for his case because he must always be in fear that the government is going to go in and try and get into his trial strategy?
Safa, your thoughts on bail on Friday?
I don't think that, unfortunately, Mr. Combs is going to make bail. It certainly is a possibility, and it'll be interesting to see how the judge takes those two cases into consideration. The likelihood of him getting bail, I doubt it. There doesn't appear to be a significant change in circumstances either, but for the disclosure of the attorney-client privileged information. And so if the judge looks at that and says, hey, this is important enough to me, this was so egregious on the prosecution's part that I'm going to grant Mr. Combs bail because I want to safeguard his rights and ensure that he can prepare his case with the integrity of his attorneys, then I'm going to grant that and I'm going to allow it.
All right, tell you what we're going to do. Safa, we're going to sign you off. You've been so generous with your time. Natalie, stick with us. We're going to take a quick break. When we come back, we're hoping to get Elizabeth Milner on, who is inside that courtroom. She'll give her perspective, her observations about what happened there. Stay with us. We'll be right back right after this.
So we're waiting on an update. We should know something here shortly. If you hadn't, man, smash that like button. Make sure you share. Drop down in the comment. Let me know what you think about this live video. So, how many of y'all think he's gonna get a bail on Friday? Now, it's a possibility that he might. Judge might probably say, "Hey, I'm gonna go ahead and grant him a bail." You know, it's a possibility because so that him and his lawyer can be able to, work on his case or whatever without any foul play or anything with the prosecution or whatever. Other than that, he may not get out on bail because this is his last bail hearing, I think, until trial. On Friday, it'll be a last bail hearing. This will be like his third one, so that'll be it. Won't be no more attempts after that, I don't think. Yeah, man. If you hadn't, man, make sure you get in the comment, you know what I'm saying? Jot down in the comment, tell me what y'all think. Also, smash that like button, share the live, man, you know what I'm saying? Subscribe to the channel, subscribe to my YouTube, subscribe to my Twitch, you know what I'm saying? All that good stuff. Don't forget also, we got the holidays coming up, man. Black Friday, Thanksgiving, then you got Black Friday. On that, got them holiday specials out. The Black Friday special gonna be going off, you know. Um, if you haven't, man, you need to get some of this gear I got. Hold on, let me show you some real quick while we wait. Let me check. Let's see, hold on. Oh, we waiting on that. Somebody said Diddy part. All right. Some of this gear I got right here that y'all gotta go to my website, man. You know what I'm saying? We got all different flavors of colors. The Drip Sport, as you can see right here. You know, really nice colors. Female is Unix. 38% off, 35.48. You can't beat that. Different colors, nice flavor colors. You know what I'm saying? Fluorescent looking color. For the women, even for the women now. You know. And we got something for the kids too as well. Hoodies. You know. Really nice ones. No cap. Like real nice hoodie. I need to get you some of these. $35. Go up here, go to that website, follow that website, malone-boutique.printify.me. It'll take you right to the website. You know, all different colors, flavors. It's a butter color, what they call it. You got that gray. You got them all. You know what I'm saying? So Get y'all one of these hoodies, man. You know what I'm saying? This not all the only thing we got. We got more than just hoodies. You know. But these are some of the new gear. I just want to show y'all a little bit. Let me get back to it. Let's see. Hold on. Let me stop showing that. I guess they ain't came back yet. Still on break, so still waiting. Mm, 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 mm. Let's see. Doo-doo. It's some of that rogue energy drink. Yeah, we're still waiting, gang. Take over y'all. Still waiting, still waiting. We wait. I tell you what I'm gonna do is make over here and some music while we wait. We'll take an intermediate break while we wait.
and basically, said that he has on tape all of these different things happening.
All right, Lord. One second, chat.
Emergency 3 p.m. court hearing in Manhattan at the federal courthouse in Manhattan. Come on in, folks. This is interesting. This is dealing with P. Diddy, as some of you might or might not know. He is facing federal racketeering charges and a lot of other charges. He's in some big, big trouble. He has been held without bond, which he does actually have a bond hearing in a couple more days on Friday. He's been held without bond at the Metropolitan Detention Center.
Yeah, we're gonna find another video. I don't really know that guy like that. Let's see. Okay. I'm not keyed on what his information. You know how some people be trying to report stuff and it's just like they're just trying to get for views and clicks. He look like, not saying he is, but he look like he might be one of them ones. So I ain't gonna promote his information. You know what I'm saying? Shit. Cause it's a lot of them out here just out here for clicks and clickbait. You dig what I'm saying? Oh yeah.
YouTube ads, you need this quick extension. I feel
Actually, you know what? I'm gonna go to the goddamn news source myself. Cause half of these more.
unlawful conduct from his prison cell.
Yeah, I want to ask you about that. Not only the search there as they kind of go about this, and you mentioned the Fourth Amendment there, the ability to go in there, but was there maybe any indication for this search? Because you imagine you don't just go in there without any idea that something, you might find something. Do you think there was any indication that this might have been happening and that's why they did it?
Yes. Prosecutors believe that Diddy is using other people's phone numbers in custody or making three-way calls to people out of custody to contact witnesses. So, you're assigned a specific number, a PAC number, PAC number that allows you to make phone calls when you're in prison. So the argument is that Diddy is using other inmates' phone numbers to contact people on the outside, or he's contacting his family members and using three-way and other software to contact witnesses through his son, for instance, with a three-way call. That's the argument here. Apparently, they have the receipts and recording of it.
All right, very good. I want to ask you about attorney-client privilege, because you mentioned it in the post as well, talking about witness tampering also falls under the crime fraud exemption to attorney-client privilege. Diddy's only real chance at acquittal is to pay off, threaten, or blackmail the victims to change their stories. Prosecutors want to make sure that doesn't happen. Let's talk about attorney-client privilege, because it's not necessarily all-encompassing. Can you describe some of that?
The crime fraud exception says that you can talk to your attorney for the purpose of obtaining legal advice, absolutely protected. Evidence can never come in, it can't be discovered, law enforcement can't get it, but you can't use your lawyers to commit a crime or a continuing fraud. You can talk to them about something that's already happened. So to the extent that Diddy is using his lawyers to tamper with witnesses, obstruct justice, and otherwise affect the integrity of the proceedings, that's outside the attorney-client privilege. So that's what that argument is.
All right, very good, because that was very interesting to me. And I want to ask about what happens from now, because let's say the federal authorities find something like this. How much more detrimental can it be for Diddy, and how will they use it in this case?
So there's a few things that can happen. The first is he's almost certainly going to remain in custody to the extent that he's engaging in his conduct. And the government will continue to these arguments during bail hearings because the defense keeps asking for bail, and they're trying to put up that same $50 million bail package with more and more restrictions. So that's one issue. How does it affect bail? It could lead to additional charges. Obviously, he's already charged with, racketeering and sex trafficking and prostitution, but they can pile on obstruction charges on top of it. Not to say it's going to necessarily add a whole lot of time, but it's going to be bad evidence that's going to come out at trial that, Diddy's trying to dissuade these witnesses who are testifying against them or blackmail them. We know that he has lots of video of them, or potentially even bribing them, either outright or through one of these civil cases. And then the third issue is he might lose his phone privileges entirely, so it can cause problems for him within the MDC. So it can affect the legal case, it could affect bail, it can even affect the privileges that he's enjoying there in the MDC and in prison.
All right, very, very interesting. I want to ask about the other side of this. If you're the federal authorities, you're raiding this cell, you're looking for possible some of this evidence as well, could it backfire for them? Could that lead to a mistrial or something happening in this case?
It could always backfire, especially if the agents that are working on the case and the prosecutors do see that privilege material. They could potentially get kicked off the case if for some reason the government does something outrageous. That's why you hear this outrageous government conduct motion. Potentially, as an extreme remedy, the judge can dismiss the case. But normally, in my experience, federal prosecutors, especially down in the Southern District of New York, they know what they're doing. It's a very high-profile case, likely to go to trial. They know how to handle these the right way. And this is something you learn even as a baby prosecutor. Don't send your agents, don't send your lawyers in when there might be privileged material. When someone has a lawyer, make sure it's someone else that's walled off from the case. So I expect that they did this the right way.
All right, my last question, Nima, before I let you go. You mentioned that immediate hearing. What could we expect to be heard there? What is the outcome of this?
Well, the judge is taking this seriously, and obviously we know that, Diddy's just like any other criminal defendant, but the practical matter is this is one of the highest profile trials, maybe the biggest trial happening in the country right now. It's almost certainly going to go to trial. So the judge is going to make sure that he takes all these allegations seriously. He hears all the evidence and so forth. I expect that defense motion to be denied, but the judge is going to hear it because, again, the allegations are very serious.
All right, very serious allegations in this most recent development, but in the case overall. All right, Nima, thank you again. I appreciate your insight as always here on Live Now from Fox.
I took two things that I love, dancing and
All right, we're gonna stop it right there, man, and keep y'all updated on what's going on with this Diddy, with these Diddy updates. Just make sure you stay tapped in, stay tuned in. Make sure you comment in the comment section. Make sure you like, share, and subscribe to the channel, man. You know what I'm saying? And do all that. Subscribe to my YouTube, subscribe to my Twitch. You know what I'm saying? Follow me on TikTok, all of that. So with that being said, man, we're gonna end this thing out with a bang. So until the next time, man, it's your boy CM the GOAT 5, Malone TV News, man. Deuces.